Hi, and welcome to the Get Local podcast. We are here today in the studio again. For those of you who probably watched our previous podcast with Doug Lineberry, and Doug is coming on our show to educate those beautiful local hidden gems that we have here in the upstate on how to keep their organization functioning on a legal basis and to educate the business owners. So we are so glad that you've joined us today. And Doug, thank you for coming back to the studio.
Thank you for having me, JoAnne. It's good to be here.
I tell you, I really enjoyed our last show, which we talked about patents, but today we're going to talk about trademarks. And I'm excited about that one because Justin and I with Get Local have actually used your services to do it. Yeah, our little trademark. So we're excited about that. But thank you again for joining us.
Absolutely. Glad to be here.
So today we're going to talk about trademarks. So
Absolutely.
Tell me a little bit about trademarks.
Okay. You see them every day, JoAnne, and you barely know what they are. That is sort of the rubric for a lot of folks because, you were mentioning yours, Get Local is a trademark.
Yes.
Hey, we filed for this one. We've got it protected. It's out there. When you're driving down Pleasantburg or Lawrence or 385, you're inundated with trademarks. You see the QT sign, guess what? They've got a trademark for that. You see those golden arches, guess what? There's a trademark for that. So what that trademark is, it's how consumers identify brands. It's how they're drawn to a product. Because we Get Local, we know, hey, we're here in South Carolina for entrepreneurs. And they know that, look, Get Local is basically a, upstate South Carolina organization that's going to be catering toward me as an entrepreneur. If you're driving down there and you see that cowboy hat and there's an Arby's on it, you know that that's pretty good roast beef.
Right.
And so you're like, hey, that is what a trademark does, is it draws you in. Let's go into the chicken wars for a second. You've got Chick-fil-A. You've seen that chicken caricature. You've red and white. Well, there's also Popeye's chicken. There's Church's chicken. And each of those brands has their own loyal fan base. And so if we take and put a Chick-fil-A sign on a Church's chicken, we're going to get confused. And that because you're like, that's not right. It's like Chick-fil-A is Chick-fil-A, Church's is Church's. But that's the benefit of a trademark, JoAnne. They help identify the goods or services you provide your consumer. Because when they see that trademark, if it's a Coke bottle, they see that caramel fluid, they see that red and white label, and they're like, they know what that tastes like. Well, guess what? If they see the Pepsi symbol, the circle, and that wave going through it, they know what that tastes like. And they know they're not the same. And that right there is the quintessential essence of a trademark.
Well, I know we talked a little bit when we came to you about our logo. Now, I create my own logo, so I'm good, right? I don't have to worry about it. I can just automatically trademark that.
You can.
You can.
Now, let's complicate. Let's say that you're like me and your drawings all look like stick figures. If you go out and use an artist, we need to make certain that, and say, for example, that, somebody else did the Get Local. It wasn't you, JoAnne. It was somebody, a very talented independent contractor. If you're going to use this as your trademark, we need to make certain that you actually own it. And now, some of the audience right now is like, well, I paid for it. Of course I own it. That's not true. There is a really strong issue that a lot of folks overlook is that not only did you hire somebody to create a trademark for you, but what they've also done is that artist will have created a copyright in the logo. And so what we want to do is to make certain that it all comes back to JoAnne Fowler and Get Local, preferably Get Local.
Right.
And you're like, well, they're the same thing. You really want your intellectual property to be held by a company. Because, it's Friday, it's a beautiful day here in the upstate, but if we go and get in a car wreck or if we go out and something happens and this logo is your personal property, anything that might be able to reach your personal property might be able to get to your trademark.
Gotcha.
So we want that to be owned by an LLC, a C Corp, an S Corp, something, some sort of business organization, not a partnership, but an actual setup. We have an LLC, S Corp, C Corp, something should own that. But back to why? Because let's say we're dealing with that independent contractor. They created this from whole cloth. You basically said, hey, I just want to Get Local and I want to look cool. You get this logo back. And you've paid them. Let's say you paid them $1,000. It's a lot of money. And at the end of that day, you come back and you've got your logo and you've got the proof of it. And you're like, man, this is awesome. You only bought that one iteration unless you have the artist assign the copyright in the trademark to the company.
Oh my goodness. Okay.
And let's be real frank on that. Because, JoAnne, you remember we did a presentation a while back and this sort of got the audience stirred up.
It really did.
And they were like, whoa, I paid for it. It's mine. You paid for it, but you only get that one iteration. Unless you have an assignment of the copyright in that logo, you've got a problem. And that problem can be the artist can come back later on. Like, JoAnne, you go out, you paid $1,000. We didn't have an assignment. You've used this everywhere. The artist comes back and says, hey, JoAnne, I like the fact that you love the Get Local. I love it. Now I need a royalty for every time you used it. Yeah, and I mean, you laugh at it, but it's
'Cause
like,
I'm going to get that letter.
absolutely.
It gives
And
it to me.
get the letter now, because, and also do that. I say now, and I mean now. You do it when that relationship is still fresh. You do it when everybody's in love. And
Maybe you're not making a lot of money right
Yeah,
now.
absolutely.
All of a sudden you become selling Jordan shoes,
That's right.
and
Yep.
they want all of that money.
That's right.
They want back money,
The next
right?
thing you know, you've got Michael slam dunking that ball, and everybody's wearing your sneaker. Well, of course, the artist is going to be like, "Hey, I need
drew
that.
that,
I
yeah.
need that," because got the Nike swoosh created by an art student who assigned it to Nike. And everybody's like, "Oh my gosh, it's such a valuable brand." Well, at the time, it wasn't. Nike had to go out and put all this money and blood and effort and sweat and tears into it and made it a huge brand. But initially, off the drawing board, it was just a swoosh. It was a check mark. And so everybody's logo begins that way, but we have to make certain that your company owns it, because if they don't, JoAnne, you run the risk of, hey, I've got the Jordan on there and it's a slam dunk and I've sold a lot of shoes. Here comes an artist thing. That's awesome. I will need $1 for each one of those pair of shoes that bears that particular trademark.
Well, now let me use this example, because I know at Winthrop University up in Rock Hill, South Carolina, the business class, the professor will often bring in a local business who maybe's just been open for a year, or maybe even a concept of a business. And a lot of times they will do everything from beginning to end. I actually participated in one of those programs, but they will design your logo. They will, put together your plan, everything. So in that scenario, when I went in, they actually designed my logo. Should I have gotten some type of release from the college for that?
JoAnne, I love it when you ask a horribly difficult question on a Friday. Personally, I would want some sort of written affirmation that whatever, and it may be there, JoAnne, go back and read the initial documentation you had when you joined that program.
Gotcha.
In a perfect world, we will have something in there that states whatever we create is yours, or Get Local Inc. or LLCs or whatever it may be. But hopefully there's language in there that states it belongs to you and it is yours. Go back and dig through that. And everybody watching the podcast is like, oh, he's making her do homework. I am.
Right.
I want you to go back, and I mean this in the real world between you and me conversation. Go check. If it's not there, we can go back and get it. I want everybody to understand that this is correctable. It's not a fatal sin. If your artist or someone or a class has not yet provided you an assignment, there's ways we can go back and fix this. But you need to do it, because if you don't, and the artist later comes back and says, hey, JoAnne, I would like my royalty for every time Get Local's on a podcast, on a cup, on this, on that, you're going to want to make certain that you've prevented that from happening. And so even if you used a third party, and by third party, I mean your brother, your mom, your dad, if it's not you, you need to get a copyright assignment for that trademark logo.
And do it early.
Absolutely do it early.
Before you're worth a lot of money.
That's
really.
right. You need it done. If it's already been done, go back and get it immediately. But as soon as you're dealing with that person, preferably you walk away with your logo and a signed assignment stating, hey, Get Local LLC, you own the copyright to Get Local, shown here, and attach a picture of it, so there's no question on what was assigned. But you would want that in all one fell swoop in a perfect world.
Now I'm going to ask you another hard question. Today, everybody, I talk to so many business owners, and as business owners, we wear multiple hats.
Sure.
But as you said, most of us aren't designers. And so a lot of times we're going to all of these free sites. So, Fiverr is a really big one right now. I think Fiverr, I'm not sure how they say it, but folks will go there and you can pay $10 for somebody who's maybe in Indonesia or the Philippines, or they may be right here in the USA, but they're going to design this logo for you for $10. What is that?
Okay. Foremost, it's more homework. You're like, man, this guy on the homework. You want to read through your terms and conditions, because guess what? It's not like the Apple one where you click I agree. We need to make certain that there's protection in there, that whatever's created and any and all intellectual property to it. Now, I say any and all, I mean trademarks, I mean copyrights, artist rights, whatever might be in there. I want it all to flow to your company. So if you're using Fiverr, if you're using another website, you need to check those details. I get it. It's horrible reading. You've got to go into it, because what we don't want to have happen, JoAnne, is a situation to where an entity, we won't name one, but just an entity, creates something and you don't own it. Or worse yet, what if they copied somebody?
Well, that's what I'm thinking. What if, like on Fiverr, let's say they did this design, which they did not, but let's say they did my USA, we put the Get Local in it, and then all of a sudden somebody else wants a South Carolina design. So now they just take the South Carolina part, or maybe they just take the Get Local part. because we don't have some kind of agreement that says they can't use any of that.
That's right. And you would want some sort of assurance from whomever you're using that, hey, my original work's my original work.
They're not going to use it anywhere else.
That's right. Don't create a derivative of it. I don't want you letting Betty or John or Sam or Tamika or whomever it is use this. I need some assurance from you that, yeah, we created a cool trademark and it's mine. Because, here comes the problem, JoAnne. Let's say that you don't get those assurances, or worse yet, what if you're the person they were looking at somebody else's and drawing it from? You don't know what they've done behind the scenes.
Right.
So you go out, you put your logo out there. The next thing you know, you get a cease and desist letter. And somebody attaches a, get local that's got a hexagon in it, and maybe it's in West Virginia, which is still a similarly shaped creature, saying, hey, guess what? What are you doing? This is crazy. Why'd you do this? So you want to make certain that there are assurances from whomever you use to design it for you that it's original, that it was not a one eye staring at their logo while they're designing yours. You want to make certain that it is original and that you own it. Harks right back to the beginning of the call. Make certain you own it completely.
Now, if you're getting bits and pieces, so let's say I get the South Carolina logo from Adobe. Maybe I get that. And then another artist from Fiverr designed my Get Local. I would need to get that from both of those guys.
You would. If you're bringing it from two different sources, you want to make certain that every source is contained. In the outline of the state, everybody's like, it's the outline of the state, big deal. Well, guess what? What if they redesign what the Charleston Harbors look like? Or what if they do something to change the way the outline looks? There could be an artistic input from them. So you absolutely want to make certain that you cross that T, dot that I.
Okay, fantastic. Now, what exactly would be trademarked? Let's use our logo again. So
Absolutely.
Could somebody just take the word local out and use a little heart and it would not be infringement on the trademark?
It depends. If you're using it for, let's say, your entrepreneurial services, and they're using it for semi-tractor trailer trucks, they can probably use that heart and get away with it. The chances of you two colliding with each other pretty slim.
Right.
But if they want to use that little heart for some sort of digital zine, maybe they want to use it for a publication, maybe it's something in an entrepreneurial field, yeah, you definitely want to be able to stare at that one, because we talked about in our previous segment that there's always a responsibility or an obligation on the owner to protect their marks. Same thing when we file at the trademark office. The trademark office fends stuff off in the application process, meaning, when we filed, if there were any marks raised against us, we had to explain how they weren't like you, how we should be allowed.
Gotcha.
Your mark does the same thing to other applications.
Once it's approved.
Once it's approved. And in the real world, though, you've got to do this yourself. So if you see that heart and it's not used on a semi truck or an air conditioner or something that's very much not you, if you see it on something that's used that is close to you, maybe it's just a local with the heart in it, or maybe it's tilted to the side and it's locality with an L or a tilde or an umlaut or something in it. You want to make certain that you're watching to see what's used, because if they're doing it in something that's similar to your vein, JoAnne, you want to make certain that you reach out to them, because a couple things can happen. Right now it's just me and you in a room having a good podcast.
Right.
Maybe they have a podcast, but it's not a good one. Maybe they have a tirade. Maybe they say some very foul things on it. And that logo that is sort of similar to yours is on this. That could have a lot of negative social impact for you. Your social media may get blown up with, oh my gosh, look at this. And so that's one reason we want to enforce. That's one reason, we want to file our trademarks federally. Right. If we can get a federal trademark, we should file for one. People ask, why? There are common law trademarks that, if we had not filed for yours, your use here will count. Problem with common law is it's only good where you're using it and advertising it. And that's a great big pile of, you've got to prove where you're at, when you were there, how you were there, and how often you were there. Guess what? Get a federal trademark. There's going to be certain assumptions made on your use, as well as ability to expand, that don't need you requiring, hey, here's a phone book from 1998 showing that I was here. Here's a copy of this coupon that I put out there. Here's a picture of the brochure that I handed to somebody. You don't have to go through those, and you get the ability for the trademark office to prevent similar marks from registering. And guess what? After the 5-year mark, you can file particular documentation to say, hey, this is mine. Nobody can ever claim ownership of a Get Local with a heart as the O in it. This is mine. And so you've got the ability to essentially be 10 foot tall and bulletproof, incontestable ownership. You don't get that if you're just common law. Another thing too, we talked about funding. We talked about entrepreneurs, venture capital. If you're going to somebody and you're wanting them to give you money, you need to show that you're crossing these T's and dotting these I's. I've thought about my patents like we talked about last segment. I filed for my trademarks. You know, I'm protecting my brand. You can tell them enforced it. Say, hey, I saw somebody in North Carolina using something similar, reached out to them, got them to stop. Because as a steward of their money, they want to make certain that that money is going to be protected.
Right. And I think, you know, if you're going to ask someone to invest in your company, you do want to, as you said, dot your I's and cross your T's. So if you've got your patent, you have your trademark, you know, you have your business bank account, you have your Dun and Bradstreet number, your EIN, your business license. Those are all showing that you've taken that step. You're not just you're not a home business that's creating something in your garage. Not that that's bad, because a lot of people start there.
Not at all. There have been some great companies, several South Carolina companies have started in a garage, but you know what? They do it all at the beginning.
Yeah.
They do it right. And that's how they start in the garage and get bigger.
That's
because if you start in the garage and don't take these protections, you're probably never leaving that garage.
Wow. So now there's the federal patent. So if not patent, I'm sorry, trademark. So if we file a federal trademark, it goes back to like what we were talking about in the patent. No one in the U.S. would be able to use that trademark.
That's right. You know, you're going to have protection from the trademark office fending off similar applications. You're going to have the ability to expand and go into other areas. The way that could work, let's say you're in South Carolina now, you're going to move to Florida soon. You may get to Florida and there might be another use of a get local someplace. If they have not filed federally, you've got the ability to fishbowl them and you can lock them in where they're at, because that is a benefit of federal. You went to the government and said, hey, I want to protect my trademark. You've got the ability to actually compress somebody and they might still be able to use their trademark, but only where they can show we were advertising it. We used it. It was in the market. And that does not count against you, because you've got a federal mark. But you've locked them to where they're using it. And that is a horrible concept. If you've got a business and you're trying to get out of it, all of a sudden, here comes JoAnne with a federally registered mark, and you're locked into Gainesville. You know, you're locked into a tiny little spot somewhere, and that's all you can ever do. And people ask, well, you know, how does that really happen? Holiday Inn. We actually had a Holiday Inn, an old one here in South Carolina before the chain. They didn't file federally. And what happened was the chain moved in, told these guys, stop, you can't be federal Inn, Holiday Inn anymore. Went up to court. The judge is like, no, they can be Holiday Inn. They were here. They were using it. They're before you. But because you, National Holiday Inn, have a federal trademark, we're going to limit them to like a 60-mile radius.
And that's it.
That was it. You can't advertise
so they couldn't expand or grow or do anything else.
You don't get to go anywhere outside that 60-mile. And guess what? If Holiday Inn wants to put one at 62 miles out and advertise all over the country for it,
they can.
Not a thing you can do.
Oh, wow.
So there are some real world ramifications on it you need to be very careful of. If you don't take these into consideration, or if you just don't think about them, you could end up fishbowled yourself, or you could end up, and this is a huge thing, JoAnne, we need to do trademark clearance searches.
Yeah.
Now, I'm a fast talker, so I'm going to say that slow again. Trademark clearance searches. You know, when we filed for your mark, we searched. We went out and said, hey, you know, what is on the USPTO? What's out here? What's similar? Because if you see somebody else using a similar mark to you, I'd advise you do something else. You know, we talked about maybe the other evil get local doing some bad things, or, you know, having a bad podcast or saying some comments to offend people. You know, what if you're a restaurant? You know, do you really want to have the same name as somebody else, especially if they're physically close to you? You know, no. You know, what if you're a brewery? You know, do you want the same name as another brewery in town who makes bad beer?
Right.
You know, so you need to be very careful on that. But before you go into business, before you buy a website, before you label a car, before you hire the guy at the sign out there on Pleasantburg, you need to make certain that those marks are clear. Now, you can do a rudimentary search yourself, but I advise you find a trademark attorney, hire them to do this search for you, because you know, those of us who surf this all the time, we know how to do it efficiently, and we'll be able to tell you, hey, are there problems here? You know, hopefully you get back, there's no problems and you need to go, but sometimes I've got to pop a balloon. Somebody comes to me with a great idea and they're like, I love this mark and I want to use it for this. I'll go look and I'll find something similar. And I'm like, you don't want this.
Good for you.
Yeah, and you have to, because if we register it for it, a couple things could happen. You're probably, if they've got a federal mark and you're too similar to them, you're not going to get past them. But there's also the real world ramification of they may send you a cease and desist letter after you've bought a website, after you've wrapped
pay
the
all
truck.
that money, branding,
Absolutely.
T-shirts, everything.
Absolutely. And then you've got to turn around and start burning stuff in the backyard, because they're like, hey, I'm going to sue you otherwise unless you get rid of this.
Now, what about like on our logo? We've got colors. So, so somebody wants to do get local. They flip the get around so that it's all straight across, and they change the colors to blue and green.
Sure.
Is that an issue in most cases?
That's awesome that you asked that. I usually tell folks, don't file for color. You know, you're probably not John Deere green. Let's just be honest about it.
Right,
But we all know that
right.
color. We say John Deere green, and everybody in the universe, because there's
They know, that's right.
there's a shirt over here on the shelf that is John Deere green. But it's like, what it looks like.
Yeah.
But I'll tell folks, don't file for color.
Okay.
File black and white, and that way it gives you a benefit. Because you know what? If you want to make this logo support Cancer Awareness Month, make it pink.
Yeah.
If you want to support Valentine's Day 1 month, make it red.
Yeah.
You want to support St. Patrick's Day, make it green. Gives you a lot of freedom. And you were
Okay.
talking about rearranging the words and stuff. It's going to be a likelihood of confusion test because, when we tell the feds what's here, we're going to say get local. And we'll describe, hey, get's going to be running perpendicular to word local. But if they turn it straight, that's not enough. That's not getting over your mark. There's no way for them to go, oh, wow, very clever. You rotated it 90 degrees. Good job. No, they're going to tell you that's too close and you can't have that mark.
Oh, okay. And then, like, for instance, on Get Local, what if we decided, now we've patented it just as it is on the screen
Trademarked
today,
it. Yep.
trademarked it, I'm sorry.
No, you're good.
So if we pull just the Get Local piece out, now we're just doing it on its standalone, is it still trademarked or no?
We actually filed for Get Local as a word mark. So you do have that ability. And that also means you don't have to use the heart. If you want it to be an octagon one day, or if you want it to be a square, if you want it to be a star, whatever you want it to be, you can have some freedom with that, as long as you can still read the words out of it. And that's what I tell folks is, logos, if it's a beautiful logo and you're welded to it, and it's going to be your golden arches, you file for it. But if you've got a word mark in mind and you don't quite have a logo, do not let that hold you back.
Yeah.
If you're going to be those words from now until you can't think of a different time, file for that word mark.
Well, and I want to say, this is not a bad situation for us, but we had on Facebook, there's somebody new that just went to the Spartanburg area, and we're Get Local, but theirs was Be Local. And so it was really funny because a lot of people said, oh, are y'all doing something new? They thought we were very similar.
Course.
And they're brand new. I mean, they're not doing anything, like you said earlier, but what if they weren't a good company and there's already that confusion? So I can see the purpose of making sure that you trademark your logo so that people don't think you're somebody you're not.
That's right.
Right?
And JoAnne, here goes further homework for you. And y'all remember from the first session, she's got homework already. So here's another one. You're going to want to have a serious consideration of, hey, do I reach out to these folks? Are they too similar to me? Is this Be Local too similar to me? What are they doing? Because guess what? The dominant part of that mark is going to be local. The be, the get, the local, whatever you might want to call it. Human beings have a tendency to focus on the dominant portion of a mark.
Yeah.
And so your homework's going to be, hey, do I need to reach out to these folks? Do I need to police my mark? Because guess what? That onus is on you. The trademark office isn't going to do it. There's not some attorney
And you're
out
not
there.
looking for it. You're
That's
our attorney,
right.
but it's
That's
up to
right.
me to find it, right?
That's right. When you see it, because I'm not driving around Spartanburg every day, peering out the window looking for things. But that'll be something we need to discuss.
And the same thing that we talked a little bit in the patent, if I've trademarked my logo, I really need to kind of, maybe type in Get Local or local and check all
Absolutely you
across
do.
the U.S. because somebody else could be using it and I don't even know about it.
And that right there is some brilliant portions of it. And I love, JoAnne, that's already hit and made a real important distinction with you is that, hey, it's on me to look because especially as a small business, you are the copy guy, you're the dishwasher, you're the payroll person, you're all of it for a while. You also need to be the Sherlock Holmes.
Yeah.
You need to be out
It's
there
your
looking.
company.
It is your company.
Every bit of it is your company, from the logo to, the customers. It's all yours.
And what if somebody comes up with Getting Local, and they're out there and they're doing crazy stuff, but they're still in the entrepreneurial world? You want to quash that. When you find out about it, you've just got to reach out to them and like, no, can't do this. You've got to move on to something else.
Right. So I love the part that, like for us, and this is where it's really good to go to an attorney, but, you said, let's don't look at color. That's not important. Let's make sure that we're covering the words. And, so not only are you doing the research, but you're also advising. And I think, it's really hard for us when we start to trademark something to really know what to trademark, right?
And it's funny because a lot of folks are like, hey, I'm going to use LegalZoom or I'm going to use something else out there. You want this because, hey, if I goof up, JoAnne, you know where my office is. You can come up and kick me around the lobby anytime you feel all right.
Yeah.
And you've got the ability to like call me. You've got the ability to be in a room with me like right now. And I will suggest to everybody that's what you want.
Right.
It's like, I get it, we're federal, but you want the ability to be able to contact your attorney. You want to be able to get on a Zoom, some way to have just a face-to-face, because if you're doing it through an amorphous organization and you don't know, hey, who am I contacting, who's my person, that person might not be there in 2 months. It might be just a, hey, you file it and we're done with you, there you go. Guess what, trademarks last forever. Now I'm going to ask you some trivia now, and I know right now you flip the script, I get to ask a question.
I don't know if I like
like,
this.
I don't like this game. What is the oldest trademark?
Oh, wow. probably 1800s,
I
maybe.
love it. That's a good guess. But it's actually Stella Artois beer, and they claim it back to roughly the year 600.
Wow.
It's old. And so
Wow. I
it's
would never
really,
imagine that far back.
but you can go to Publix right now and see Stella Artois on a shelf, still using it. And if you're using a trademark, it lasts for as long as you're using it.
And the same thing, I guess you said with patents, we wouldn't want it to be my personal trademark. We're going to want it to be a
Absolutely.
trademark of the LLC or the
Absolutely.
corporation.
Get Local is going to belong to the LLC or the S Corp or the C Corp. Same thing for Stella Artois. It belongs to the distributor or the patent holding company or trademark or IP holding company that owns those materials. You don't want it to be a personal asset.
Yeah. Now, what about you? Because you were mentioning earlier about contracts and getting the trademark set up. I know if you go and Google on the internet, you can always file your own trademark. But I would assume it's very legalese when you're filing that to some degree.
It's deceptively simple. It's one of those things that you're like, man, I got this. I got this. I have a client, and I have their permission to tell you this story, Fostering Great Ideas. Y'all, tremendous organization. David White's the leader of it. They help foster children. They have some fantastic programs that help the South Carolina and now elsewhere and international that help foster groups keep these families and kids together.
Oh, that's great.
David and I met at a very similar thing. It wasn't a podcast, but I was actually presenting at the Greenville Chamber. David stood up at the back of it, and y'all, you can call him on this. He knows that I do his work for free, and part of that is I get to tell the story because it's important, but not to make fun of them because, he runs a great organization, and they at the time had a shoestring budget. David had filed a lot of trademarks on his own and had stood up at the back of this. And again, I'm at the front, he's the back going, I filed them, they're easy. He came back to me later and said, hey, I've gotten all these office actions and I don't know what this means. And he had filed Fostering Great Ideas as a foster care agency, and it's not. And that's wrong. And when you file a trademark application, it's set in stone. You don't get to amend it. You don't get to undo it. You can't erase it and say, my bad. So all of those trademark applications were wrong. They all could not go through. I fixed it. I went back. We got all of them allowed, but we had to do it a correct way. And therein lies the rub. You can fill out these forms. You can fill out this application, and by gosh, it looks right. But then you're going to get a communication back from the trademark office. And their communications to David were, you're not a foster care agency. You're an independent group that does some great work, and they really do great work. But it's like, you're not a South Carolina foster care agency. And so you can't file for this. But guess what? You can't amend it. So all of those filing fees are gone. They're just up in smoke. They're gone. And so that's what I'll tell you, JoAnne, is you're going to be tempted to do that on your own. If you don't serve folks, don't start.
Yeah.
Because it really can blow up. And you might make a lot of mistakes in it. What if you aren't very considerate about your classes? Because, hey, the USPTO is actually, they pay for themselves. They're a fee-driven organization. When we filed for Get Local, we had to pay a filing fee for it. And if you file it in a lot of classes, like, say Get Local had a clothing line, and maybe you opened up a spa, and there's the entrepreneurial line, and there's also some handbags. All of these are distinct classes of goods that can infer a separate fee. And so you've got to be really careful. Like, I'll have clients come to me and be like, I want to file in all these areas. And I'll sit here and just do the simple math and say, hey, my time's going to be X for this. And you're going to ask, what's pricing for a trademark? It depends. I roughly budget for the attorney's fees for searching and filing it between $1,000 and $1,300. That's a good number. Your USPTO fees are going to be either $250 if you fit within a prescribed USPTO designated language, or if you're unique, like we were talking about our banana-shaped welder for our one about patents. If we want to file for banana-shaped welders, there's not going to be a PTO structure for that. So we're going to have to pay $350 and describe it. But if you do that for a lot of goods, you're going to be hit for a fee for each different class.
Wow.
And so guess what? LegalZoom or whomever you're going to use, you can click those boxes, and all of a sudden they're like, okay, your filing fees are going to be $2,800. You went into X classes and you've got to pay me for it. You want to sit down with your attorney. You want to go for your core. You guys are entrepreneurial focused. We didn't file for sweaters. We didn't file for ice skates. We're not going to.
Right, because we're not going to do those things.
That's right. And we don't need that. And even if you've got big ideas, you want your initial trademarks to be on that core. You want them to be, if you're a clothing line, you're filing for clothing. You're not filing for tumblers. You're not filing computers. You're not filing for car tires. You want to aim right to where the core of your business is.
So let's say we expand though. Now all of a sudden you filed it and I
Yep.
do want to do a clothing
Absolutely.
line.
Now we're a clothing line.
So I just come back to you and
You
then
do.
we file again?
You do, and you can come back to me, and you want to be very careful too, because you'll have people. Clothing is a great example, JoAnne. Let's say that you guys are going to make evening wear and formal wear. It's going to be the get local. You think of us for the next prom, for the next cotillion, whatever it might be, and you're like, hey, we're going to file it. I will tell you to be very careful, and this is something a lot of people don't think about when they file their own. Go broad. Go broad. Describe it as clothing tops, clothing bottoms. Because guess what? Find me a top and a bottom doesn't fit on a human, and you've done something really weird. But yeah,
it's great.
It really is. Because if you put in there, oh, I'm going to be bow ties. Well, guess what? You're protected for bow ties, but then maybe you stop making bow ties, and in 5 years, remember we talked about trademarks are alive. They're alive because you continue to deal with the trademark office. At the 5th year, at the 10th year, and then every decade after that, you've got to show use. So let's say you filed for bow ties for Get Local. We all decided, nope, bow ties are out. Nobody wears bow ties. We're jackets. So at the 5th year, instead of sending in a picture of a bow tie that's got your logo on it, like a tag or branding or packaging or something, you send in something that's got a jacket on it. PTO is going to write back and be like, no. Said you're bow ties. You can't send me a picture of a jacket. That doesn't work. And so you got to be very careful with that. And you don't get that unless you go to an attorney to discuss it, because you can fill out the form and it'll let you. And it's not going to warn you that, hey, you're being very narrow, or hey, you should consider expansion of your brand. It's just going to say, okay, if that's what you want, click on it.
Yeah. Well, I have one last question for you. I want to talk about AI.
Yeah.
Because I know lots of small business owners who have told me that, and I use AI myself some, if you're trying to get some words together and you just can't really figure out how to say it or how you want it to say, you can throw it in there and they'll come up with a good paragraph for you. However, a lot of folks are using it for contracts.
Sure.
So, if someone's going in and they're trying to can they use AI to do a trademark? Or is that something that you really can't use? Or
that's a good one. Remember, your trademarks are based on their originality. I have had a client find, we don't have it registered yet, so I can't tell you, but I've had a client generate one with AI. And it was very beautifully nonsensical. And they're like, people love this thing. The AI came with it because, the AI was just kind of being crazy. And they're like, this is an awesome trademark. But the AI came up with it. But the same rules apply. If you want to file for it, get a search. If you go to an AI and say, I want a trademark for, this guitar, and it hits you back with something, that's all well and good, but you still have to do your patentability search. You still have to make certain that's okay, because even though the AI created, guys, just remember, AI is not actually intelligent. It's an information gatherer. Kind of think of a lobster with its claws, just bringing stuff into it. And so a couple things you want to be careful of. If you thought, hey, give me a really cool trademark for guitars, and it comes back with Fender, then maybe you shouldn't file that one, but do that search. There is a certain amount of common sense that flows with that artificial intelligence that it lacks. And so if you ask it to create one for you, there you go. Now, you mentioned an important distinction, though. You were talking about contracts. Absolutely, positively, and please don't misunderstand me, folks. Looking at the camera now, do not use AI to create a contract. And you're like, it's the attorney saying use an attorney. It is. Yeah. Because guess what? We're in this beautiful state. We're in South Carolina. You take a contract that obeys our laws and fits within those boundaries and is as broad as it can be. You go to New York with it? Go to California with it? Try to take a California document here and see what happens. Bring a New York document here or a Texas document here, y'all. We're 50 states. And again, we're grouped into judicial circuits, but even within those circuits, the states are still distinct from each other. So there may be things that the AI absolutely doesn't understand, because remember, it's a lobster and it's just out there pulling in info. And you're like, I want a contract. I want a licensing agreement. Give me a licensing agreement for guitars. And it goes out there and pulls all this stuff in, and you look at it and you're like, this is cool. What a contract. You have no idea where it got that from.
It could be information from 4 states,
it
right?
Could be 50.
Realistically.
It could have something from all 50 states in it, and you won't know, because the AI is not going to stop like, JoAnne, pause for a minute. I pulled this from Alaska. It's just going to say, here's your contract.
Yeah, here's your contract. And then the other thing about it, I always worry oftentimes is AI is not really 2024.
That's right.
And so maybe some laws have changed from the information that they've just put in your contract in the last 6 months, the last year.
And remember too, AI tends to look for the big conglomerates of info. The older info obviously is going to outweigh the newer info. And remember too, a worry with AI is you can cause it to hallucinate. And you're like, how do you make an AI hallucinate? We're about to teach you. That's going to be our little takeaway from today, is how to drive an AI crazy. Let's say that you and I are like, we want to test an AI. And we're like, you know what? Let's get an AI convinced that polar bears are vegan. And so you and I are going to start typing articles on it. We're going to call our friends and tell them to start typing articles on it. We're going to tell people to start tweeting that polar bears are vegan. Once you hit a critical mass of that information, you can cause an AI to, and when you ask it, what's a polar bear? If you've hit a threshold with that information, if you've provided that enough, you've got the ability to make that AI hallucinate.
And believe what you've been writing.
Just due to the mass of it, just due to the mass of the data. And so that's a problem. You know, it's a big lobster. It's clawing all this stuff in. It's not thinking. It's not looking.
Yeah, it's not intelligent.
And if all this stuff it's been clawing in says, hey, polar bears are vegan, and there's all this fresh data that says polar bears are vegan, you know, we're falsifying reports. We've got a National Geographic report out there going, polar bears are totally vegan. They all eat carrots. You're going to see AIs, once you hit a certain threshold of that information, be like, yeah, polar bears are vegan. So you've got to be very careful of it. A great example in the legal industry, we had a case from New York. Attorneys used AI to generate a brief. It actually made up case law. And I don't mean it went out and found bad case law. I mean, it created case law that was not real. The attorneys did not check behind it, submitted the brief to the court. The court did check behind it and was like, what
the judge
case?
Was like, what are you doing? I remember seeing that one.
It's like, what case is this?
And that was early on when AI first came out. I remember that.
But that's also sort of the benefits and the booms of it, is that, hey, it can do some really wonderful things, but it can do some really broad things too. And you need to make certain that you're writing herd over it. You know, if you say, hey, create me a trademark for a guitar, and it comes back with Fender with 2 R's behind it, you're going to have to be very careful of that. Yeah. It doesn't mean you get to forego like your clearance search or any of the common sense things that an entrepreneur should do to protect it.
Well, I really appreciate you coming into the studio today to talk about trademarks, but I do want to tell our listening audience, you know, one of the things I think with new businesses you struggle with is I don't have the money to go see an attorney. But I'm here to say you can't afford not to go see an attorney.
I agree.
Because the challenge is when we try to do a lot of things ourselves, we don't do them very well.
That's right.
As business owners. And then we're talking about very big legal issues between patents and trademarks, legal issues that we could be sued, or money that we're losing because we didn't do it. So it's worth it.
Have an entirely rebrand because you got too close to somebody's mark and didn't mean to.
And you didn't mean to. Absolutely. So thank you so much for coming and talking about
Happy
trademarks
to be here,
today. It is wonderful. For all of our listeners, I just want to say thank you for joining us today. We are over at 864 Sound. You guys have to come check it out. Brandon has really completely done his studio. He does podcasts, voiceovers, anything audio. He is like the audio king and video king. So you guys have got to come check him out. For all of our listeners who are following us, I hope that you will like and share this information. For all of the Get Local Connect members, this is some fantastic information for you for your business. Please listen and give Doug a call.
Feel free to call me, email, whatever's convenient for you.
And listen, again, we want to say thank you to Brandon. Come over here and check out his studio. He's on Sweetbriar Road. You can give him a call. He's on social media, 864 Sound. And for all of us, thank you so much for listening. We could not do this podcast without you. We are so appreciative. You can watch us on YouTube video, or you can listen to us on all of your favorite podcast channels. Thanks again for joining. And until next time, bye.